Hello, this is Ben Ruley with the Stearns County Soil and Water Conservation District with your weekly conservation report. First thing I'd like to talk about is the Minnesota buffer law. Give an update on where we're at in Stearns County and provide some additional information about the Minnesota buffer law and public waters. The Minnesota buffer law was signed into effect June of 2015. There were some amendments in 2016 and 2017 that further clarified the application of buffer law requirements to public waters, provided additional statutory authority for alternative practices, and allowed landowners to be granted a compliance waiver that would effectively push the deadline out to July 1st, 2018 if they let the Soil and Water District know of their plan to become buffer compliant. The buffer law required that soil and water offices would inform landowners in their county if they were affected by the buffer law and had any potential compliance issues. So last spring, 2017, the Stearns Soil and Water Office worked on getting maps together and letters and sent those out to 298 landowners in Stearns County that appeared to have some compliance concerns on public waters with the required 50-foot buffer. The letter also let landowners know that there was potential flexibility on the 50-foot buffer. The alternative practice component of the law allows for potential flexibility on the 50-foot buffers based on a number of things. One thing that we're allowed to look at is existing conservation practices. Landowners who had addressed erosion concerns in their field via waterways, water and sediment basins, terraces, and other similar practices are allowed to use those as a credit to show that they're getting comparable water quality benefits through other means than the buffer. Another thing that we consider is negative slope. The law says that if water is not flowing into the channel through negative slope away from the channel or bermed areas, the Soil and Water Office can field verify this and potentially allow a landowner to establish a 16.5-foot minimum buffer and be compliant with the state buffer law. Along with that minimum buffer, though, the landowner may have to do additional things. Open tile inlets in the field require some treatment. That could be a grass buffer around each open inlet or a rock closed inlet. Another thing we can look at when you have positive slope is the USDA filter strip standard. In those cases, we actually look at the acres of water, the soils and slopes that are adjacent to the channel, and with that tool, we have the potential to sign off on a 30-foot buffer. If you have any other questions about alternative practices or the Minnesota buffer law, we encourage you to contact the Stearns County Soil and Water Office for additional information. Of the 298 letters that we sent out to landowners, we had 152 landowners agree to establish the 50-foot buffer or let us know that they had already done so. We are currently at 97.9% compliance rate on the 50-foot PWI buffers in Stearns County. The remaining landowners of that 298, the majority of them requested an alternative practice assessment with our office. We had 148 requests to do this. To date, 88 landowners, we've completed their plans and have an agreement on the plan that they are going to use to become compliant with the state buffer law. We have additional 31 that we are finalizing plans on or have sent plans to landowners and are waiting to find out if that's something that they are willing to do. And we still have 29 plans that we're still working on. For landowners who do not work towards compliance, the deadline was November 1st of last year to install the buffers. Of course, landowners who are working with us or had requested an extension are still in compliance with the law because they have an extension. But for landowners who are not working towards buffer compliance, Bowser, the Board of Soil and Water Resources, is the enforcement agent in Stearns County. At some point, the landowner will receive a notification from Bowser that they are out of compliance. Upon receiving that notification, the landowner is given 11 months to become into compliance. If a landowner does not work towards compliance within those 11 months, there is a financial penalty for noncompliance, and that is $100 a month for the first 6 months after the 11-month grace period. After the 6 months of $100 fines, the fines escalate to $500 a month until a landowner can achieve compliance. We've had a lot of questions from landowners on why a channel on their property is considered to be a public water. Public waters were defined through an official process ordered by the state legislature in the late 70s and early 80s. The main criteria for a channel to be considered a public water was that it was a natural or altered natural water course with a total drainage area of greater than 2 square miles. This means that the public water classification followed a channel that was straightened and ditched over the years. On another note, being that these waters are considered to be public waters of the state, the DNR has jurisdiction over any work that is done in the channel, which would include cleanouts and other types of maintenance. The DNR does have a permit process available for landowners to work with who do need to do maintenance or cleanouts on those public water ditches. It's recommended to get in touch with your local area DNR hydrologist for further information on this. Once again, I'd like to remind you, if you have any questions on the Minnesota Public Waters or the Minnesota Buffer Law, to contact your local Soil and Water Conservation District. This was Ben Ruley with your weekly conservation report. Thank you.